Welcome. This is a live recording of a virtual presentation held in February of 2025. Our speaker, Margot Gordon, outlines the crucial documents every parent should have in place to secure their child's future and offers information on how parents can create a sustainable financial future for children with special needs. The Foundation for Hearing and Speech Resources is a grassroots Illinois nonprofit that creates and funds innovative programs that help children with hearing loss participate fully in society and live into their fullest potential. To learn more, visit FHSR.org.
It is my absolute pleasure to introduce today's speaker, our presenter, Margot Gordon. Ms. Gordon concentrates her practice in estate planning and administration. She works with both individual and institutional clients and routinely represents fiduciaries in probate, trust, and guardianship administration matters. Her clients benefit from her years of experience and her in-depth knowledge of estate planning, trust, and probate law. Ms. Gordon has been designated a top legal professional in the field of estate planning, repeatedly recognized as an Illinois super lawyer, and named a top lawyer in estate planning by the Legal Network. She's authored guidebooks on estate planning and asset protection planning for the Illinois Institute for Continuing Legal Education, the premier legal education guide to Illinois attorneys. She also regularly authors articles and guides for both the Illinois and Chicago Bar Associations. Ms. Gordon handles a wide range of estate planning for her clients, including business succession planning, charitable planning, and other tax reduction strategies. She also has vast experience in planning for clients with special needs, which is why we've invited her to be with us here tonight. So Margot, please take it away as you are ready.
Well, thank you. I want to thank the Foundation for Hearing and Speech Resources for inviting me to do this and for Kate Spellman setting this up. It is 7:00 at night on a Tuesday night. And so I encourage people to ask questions as we go along. I will probably stop at each stage and see if there are any questions. Otherwise, we'll fall asleep. And when I fall asleep, I snore. So you really don't want that. So let me kind of go through my sort of loose outline of what I thought we'd address tonight. The first is kind of an overview of the need for estate planning generally, what our default estate plan is if we don't have written documents, what are the benefits of having documents. Then I'd like to segue into special needs planning specifically and considerations there. And then finally, I thought I would address some ancillary matters that came up with some of the questions, like 529 plans, a little bit of life insurance, considerations like what to do as your children become adults, how to address a child with disabilities when you have other children that don't have disabilities, and then sort of a sort of a final recap. But I'll sort of ask questions of you or check in as we go along. Does that sound good to everybody? Okay. All right, so let's talk about what happens when we don't have a written plan. Every state in the union has a backup plan for us, and Illinois is no different. So in Illinois, if you don't have a written plan, and I'm going to make certain assumptions for this, that because of the population that you serve, that this is mostly married couples with minor children. What happens if you don't have a written plan, any assets that don't pass by operation of law, that you don't just sort of have in joint tenancy with somebody, will go through probate potentially if you have more than $100,000 of assets. But more importantly, what happens is your spouse gets half and your children get half, regardless of their age. That is rarely what people want. When you have minor children, the additional problem is that you then need to open minor guardianships for them. And each and every expense for them has to get authorized. And then the children get the money when they turn 18, which is also rarely what anybody wants. Probate is also a huge expense. If you're over $100,000, you're looking at $5,000 to $10,000 to go through a probate matter. Plus, there are huge delays. So all of that is to suggest that, obviously the goal for all of us should be to create our own plan that would probably look differently. How would it look differently? I've been doing this a long time. I don't think I've really ever seen people split between children and spouses. Typically, people want to provide for their spouse and then only their children after that. They rarely would ever want guardianship for their children. The expense, it's all public record as well. Um, it also means that your children get those funds when they're 18, which is also um, I can't even imagine a scenario where people really want that. I now have kids in that range, a little bit older, and I can tell you, as they get older, I only want them to be even older before they get assets. So those are some of the considerations. The other more important consideration is the impact if you have a child with a disability, and what would happen, right? Probably you may never want that child to get funds, or certainly you want there to be guardrails in place to consider a time or events when they would receive those funds outright. So that is one of the benefits of planning. When you're looking at planning, some of the sort of traditional documents are what is called a pour over will or a simple will. A simple will is just that you put everything in the will, but it does require probate. A pour over will allows you to say, if I miss anything, it goes into my trust, and your trust becomes the will substitute. The benefit of a trust over a will is that it's private. Um, and so that is a document that we typically recommend to clients. In addition to those documents, the other documents that are routinely addressed are powers of attorney. And these are for yourselves as parents. If you can no longer make decisions for yourself for either healthcare or property, this will allow you to name individuals that can make those decisions for you at a future time. At the same time that that's done, you're typically looking at asset retitling and cleanup. And so there can be deeds or beneficiary designations for real estate called transfer on death instruments. You can also, if you own businesses, you can assign them into the trust. So it allows you to try to make sure that not only the paperwork is in place, but the actual assets will flow into the trust. I know that was somebody's question, like, how do you get things in there? Any practitioner you work with should not only prepare documents for you, but should also make sure that they've walked you through what is going to happen, or tell you that as part of their planning process with you, that they are going to advise you how to arrange for that. Okay. Are there any questions generally about planning before I kind of segue into special needs planning more specifically? No.
Do you want to say a word, Margot? Something that I have heard people frequently bring up at this stage is, do I need an attorney? Are
To
there
do
situations?
plan.
Yeah. Are there
So
situations where you can do this yourself, quote unquote, or is this something that you want to consult a
no,
professional?
I mean, so there is something called a poor man's estate plan, which is that you put everything into joint tenancy with the people that you name. That can work, but you can have problems. If you name somebody, and circumstances change, that individual becomes disabled, that individual predeceases you become disabled before that happens, you forget to name somebody on one of your documents, then what you've done is not complete. So I would say if you had very few assets, that might be a solution, but that is not, in my humble experience, I've seen a lot of those go awry. Our firm actually does a great deal of adult guardianship work, and we see a lot of folks who wind up um, under guardianship too, because they didn't do powers, at a minimum, doing powers of attorney. In fact, one of the reasons I became a planner was years ago, I used to work at the Cook County Public Guardian's Office, and I handled a lot of adult guardianships. And I realized if people had 2 pieces of paper, they could avoid that at a minimum. So I'm not a big fan. And unfortunately, I think it's difficult for people to do the planning themselves. If you're just going to do powers of attorney, you might be able to do it. But I want to point out that a power of attorney for healthcare requires a witness that's independent, and a property power of attorney requires both a notary and a witness to be present during the signing of the document. More often than not, when we send our clients copies of their documents because they want to do them on their own. They get the packet with all the instructions and they say, you know what, I got to come in. It's too complicated. So, yes, I highly recommend it. There are folks out there too that can do simpler planning for people. If you really just need, if I die, the following 5 people are beneficiaries. There are people who will do that for a flat rate. That is not what we do, but it will work and it would be better than the default typically. Okay. Anything else on that score?
I did have a question because I have been offered like services like to plan a will, and it's like a online um database or whatnot, and through different like medical societies that kind of offered it for a family because of my child's medical issues. So that is very different than what you're saying, because that would just be like a will but not the powers of attorney and setting up like a trust, I guess.
Yeah, it sounds like it. I mean, I don't know what service they're suggesting, but
I
a,
think
a
I
will
think
would
it was
just.
like freewill.com or something like
Oh,
that. So
interesting. Okay, I have not heard of that. Yes, a will would at least allow you to provide specifically for a particular individual if you wanted to, or individuals that might be different than what occurs under state law. You save some, even if you do a will, you save some money if you wind up in probate court, because at least you usually waive something called a surety bond, which is an additional expense. But yes, it is absolutely different than what I am talking about. What I'm proposing is that in an ideal plan, you're trying to avoid probate court and you're trying to just use your will as a device, sort of an emergency device, if you didn't get everything into your trust for some reason or you forgot one asset, but that the vast majority of your assets would flow under your trust, which would be private. You would be able to name whoever you wanted to both manage it through your death. Can divide into sub-trusts, which we'll talk about in a moment, which is where we get into sort of the special needs planning for either a spouse or for children until certain ages or until certain events when you felt comfortable that they could either take over or it could convert to a special needs trust. So it gives you some flexibility. Does that help answer that question? The other
yes.
thing is, yeah, is that the powers of attorney are really critical. I mean, for your own, to avoid guardianship yourself, right? I mean, guardianship is a pretty dehumanizing process, right? You basically, a court is telling you that you are legally incapacitated and that someone else is getting to make decisions for you. And even when people are compromised, they will often say, "But I'm not disabled. I don't need a guardian." And all of this is public record information and all of your assets are public record information. So by just having 2 pieces of paper, you avoid that. And as long as you name people that you trust to handle those things for you, they can do that and they can work with you as long as you have some level of capacity to do that. And having a child with disabilities, you can do that for your child as well. Um, you know, Disability is fluid, right? And children can have some disabilities but still understand enough to be able to execute powers of attorney themselves. I work with clients all the time who are getting disability benefits, but they're able to execute powers of attorney and they're not under a guardianship court, or they don't have somebody that's having to report annually to a guardianship court about their care, and they were able to name individuals they trusted to make those decisions for them if needed.
Okay. Can you review again like the basic documents then again that you need, like you were saying, I think it's 2 or 3.
Well, the ones that I recommend are, like I said, a pour over will. And by a pour over will, I mean, it's really the document that says really my planning is in my trust. So if I need to get anything done, I'm going to get it in my trust. A pour over will can also be a place where you indicate who you would want to serve as a guardian for minor children if something happened to you. It's an expression of your wishes. So it's really a court that appoints guardians, but at least they can look to the will and say, well, this is who Sally wanted to name for her son. So that's what that document is. Then the trust document, it's what you'll have heard is a living trust, a revocable trust, but it's really just a will substitute. It doesn't get filed with the probate court, but it expresses wishes for you. You are the beneficiary of it during your lifetime, and it's completely for your care. And then if you pass away, you get to dictate what happens. You can continually change it as long as you're alive and competent. I mean, not that people want to do that every day. I mean, as I joke, going to see an estate planner is worse than going to the dentist. But when big life events occur, you can revisit that plan if you need to. But if you have a good plan in place, you may never need to revisit it. You may be one and done. And then the powers of attorney. And there are two types of powers of attorney in Illinois. The first is a power of attorney for property. It's called property, but it's really a financial power of attorney. And it allows people to make decisions for you related to your finances. The reason you need a power of attorney as well as a trust is that there are some assets that during your lifetime you own and you cannot move into a trust. For example, retirement assets. And those often make up the majority of people's assets. So if you become incapacitated yourself, you will need somebody, even if you have a trust, you will need somebody to manage those retirement assets for you and take distributions for you. And it might be as simple, and typically you might name the same person. You might name someone to handle your trust assets and someone to handle your non-trust assets. That individual who's under the power of attorney can move as much as they can into the trust, but then can continue to put, for example, required minimum distributions or distributions into the trust. The last document is the healthcare power of attorney, and that's for somebody to make healthcare decisions for you. And again, physicians are not going to look to your agent to do that. They're going to look to you, but there may come a point, even if it's short term, where you cannot make those decisions. And so that's what the healthcare agent would do for you. Those individuals do not need to be the same as the people you name in your will, trust, or property power of attorney. I mean, none of them need to be the same. I recommend that you, when you're doing all of the financial documents, basically the will, the trust, and the power of attorney, that you really consider naming the same individuals for consistency. Does that help? Anything else?
Can I ask a question?
Sure.
Yes,
All right.
thank you.
Um, for the power of attorney with the healthcare and the retirement, why can't the retirement assets go into the trust?
It just isn't, there isn't that's just how the laws were written for retirement accounts. They're always your personal property. They're your personal property, but what you do is you designate your trust as the ultimate beneficiary. So if something happens to you, I mean, depending on your plan, you might, if you're married, you might name your spouse first, but then make the backup plan your trust. But that's typically the simple answers. You make it your trust ultimately, so that once you pass away, then it goes in there and it's handled through the terms of your trust. But while you're alive, you own it.
Okay. Thank you.
Sure. Anything else?
I have a question from the chat, but it's about naming who you can name to take care of a child. Do you want to cover that now, or does that fit in later?
You can name. You mean who can serve as a guardian?
Yeah, the question is, can you name someone other than a biological parent? So if the parents are divorced,
yeah,
can you supersede the other biological parent by naming someone?
Yeah, and that's a great question. The answer is no. I mean, you can, but no court is ever going to override a natural parent's rights to children unless the rights were terminated, which again, that's a highly unlikely scenario. So what you're really doing when you're naming your wishes for who would serve, it's really who would serve if both natural parents were gone. Or for some reason, I suppose, if a parent declined to act, although truthfully, I have had cases even with parents that have been out of the picture come back in circumstances where the custodial parent, passes away. But so then you really just name people that you trust. And again, what I want to be clear about is what you're doing is expressing your wishes as to who those individuals would be. At the end of the day, it's a court that you petition with paperwork to a court to designate who the guardian is for the child. A guardian only serves until the child reaches 18. Which now that means that they are their own legal decision maker. But this is also why trust documents and planning are relevant, because you can slow down while they are technically adults. You don't have to give them their money at the age of 18. You can decide at any age when you feel they're ready for them to receive funds, or to manage the funds themselves, or maybe never, depending on their circumstances.
Thank you.
So I want to switch gears a little bit now and talk about sort of how special needs planning ties in with general estate planning. I mean, special needs planning is really just designed to protect an individual who is disabled, and typically in special needs planning, the term disability is defined by the Social Security Administration's definition of disability. And that is someone who really is not able to be fully employed. And if they meet that definition, then they may be eligible for means tested government benefits. And by means tested, I mean that they qualify for benefits even based on the fact that they have no other sources of income. For the reason you do special needs planning to ensure that is it will allow those individuals to become eligible for other services. The Social Security income is not, I mean, it's not terrible, but it's not going to be enough for somebody to live on. It's a very small amount of money. You might get some food stamps. It's really that you might also then qualify for residential placements or community independent living arrangements or all sorts of other benefits out there. But even if somebody doesn't qualify for means tested benefits or does not meet the definition under the Social Security Administration, special needs trusts can still be helpful if you have an individual who has a condition that changes from time to time and has good times and bad times. It protects against exploitation. It can protect against divorce, all of which could be, a child can be at greater risk if they have disabilities. So special needs planning can really ensure that. There are ways to do that without calling it special needs planning or having it be a kind of a trust that has guardrails and that can convert to a special needs trust if and only if the individual meets the definition of disability under the Social Security Administration's definition. But let me talk a little bit about that because not the definition, but the types of trusts. So special needs trusts come in two flavors, essentially. They're ones that an individual creates for a disabled individual. So I create one for my child, okay? That is what's called a third-party special needs trust. I can do that at any time. I can do that as part of my planning. Remember, we were talking about revocable trusts. If I have concerns and I'm sure that I have a child that is now old enough and is now getting SSI, I can, instead of their share going to them outright, I can direct it under my document into a trust, create like that is part of my revocable trust. It's really just an article of the document that says, my son John's share is going to be held in the, John Doe Special Needs Trust, and set the terms. And the terms are that, it's designed to ensure that John has a fulfilling life, but that he is also qualified for benefits as needed. If there is something that he would benefit from that might impact his benefits, it should be written in a way that's flexible enough to allow for a reduction in benefits if that's in my child's best interest. It would also have language limiting access by John to these funds. So for example, and it's not intended to be demeaning, but to be protective. So For larger expenses like a home or a car, it would be designed so that those items are owned by the trust. Keep in mind that a revocable trust is not creditor protected, but when you pass away and trusts get created under your revocable trust, then it does become creditor protected. It has the potential to be creditor protected, I should say, depending on who's serving as the trustee. So there's that also, that protection, right? That your son can't now engage in conduct that then lose all of the money. So one of the things that comes up a lot, I get a lot of questions about this because practitioners, handle things a little bit differently. You can have a standalone special needs trust that you create as part of your plan, that can either be revocable or irrevocable. That is not part of your own revocable trust, or you can, as I said, incorporate it into your revocable trust. Typically, and I know some practitioners do standalones all the time, but my practice is only to do standalones if there's a plan by other family members to make gifts to an individual with disabilities, or there's a plan for some kind of gifting at the time. Otherwise, it's perfectly fine to have it within the larger trust agreement that you have for yourself. So in a scenario where you have one child with a disability and one child without, you can have a trust for the child without a disability that might terminate at certain ages or distribute out at certain ages, and then you would have the special needs trust that would not. So what are some of the considerations for that? If you're going to have a trust for the lifetime of your child, you're going to have to think about who's going to manage that, because most of the people you would think to manage it could very well predecease your child. So we strongly encourage you, as part of that planning, to both name those individuals, but ultimately name a bank or not-for-profit trustee that can step in, and potentially name maybe family members or younger family members, even siblings if they're old enough, to be able to remove and replace if for any reason they need to do that. But that really not have the children, your other child or children, serve as the trustees. The last kind I want to talk about is what's called a springing special needs trust. Sometimes you have a situation, even when a child has a very serious diagnosis, where you really don't have the sense that the child needs a special needs trust, and they're old enough, or you feel like they're going to feel badly if they're treated differently. So you want the document to look as if you're treating all the kids the same. In that case, what we often recommend to clients is that they do something called a springing special needs trust, that they treat all the children the same, that they maybe even have withdrawal rights, but make it subject to the trustee that's acting to determine that they will allow those distributions. And there's a provision in the back of the document that says at any time we can convert one of these trusts to a special needs trust, so that if the child is able to be independent and hold down a job, and there really doesn't seem to be a need for a special needs trust, that it never has to get created. Or certainly it can be looked at a later time when the parent is gone. In addition to third-party special needs trusts, one of the other things that you hear people talk about with special needs trusts are first-party special needs trusts. What that means is it's a way to it's a special needs trust that is designed to shelter the assets of the disabled individual who worked for a period of time or inherited money and there wasn't a plan in place. So it's really a different form of a trust. It's sheltering the individual with a disability's own assets, and it has slightly different provisions. It also has some limitations. You can't fund a first party special needs trust for an individual after they reach the age of 65. Whereas you can create a third party special needs trust under your documents for individuals at any age. So those are kind of the main flavors of special needs trusts. I don't know if there are other questions about how they operate, or and then before we kind of talk through some ancillary issues related to special needs planning. But that would be what you would want to do in terms of incorporating planning for a child with a disability.
don't see any questions in the chat. I think we can go ahead.
I have a question.
Oh,
Sorry.
great.
Sure.
Okay, so you mentioned, sorry, I'm just reading through my notes here, because you mentioned it a while ago. Talking about putting, like, with the child with a disability owning a car or a house, right?
Mhm.
If, for instance, they trust owned the car, right? And they got into a car accident or something, could then the trust be sued? Like, how does that work?
So the trust has a provision called a spendthrift provision, and this is true not of just special needs trust, but any irrevocable trust, okay? And which protects against creditors and judgments. One of the reasons it's protected under Illinois law has to do with the fact that typically with a special needs trust specifically, you never have the child serve as the trustee. So there's always a different individual and or bank serving. So it is actually creditor protected. They really can't go after the trust if it's owned by that individual. I mean, one of the considerations obviously is, you know, you want to make sure that the child is able to drive. There's no prohibition based on the disability from driving, but many people with disabilities drive, or many people have disabilities that drive that don't impact that. So I don't think it's any particular problem having a car owned by the trust or a home. You would have insurance on both, remember, and that insurance would be able to pay out if there were ever any sort of an accident.
Okay, thank you.
Sure. Anything else? All right, so let's talk a little bit about some ancillary issues, because these were based a little bit on some of the questions that came in before this discussion. One had to do with what do I do about saving for a child with disabilities, and this comes up a lot, and I just want to mention it. One, I'm going to just point out that it's hard and it's difficult to be able to save funds for a child with disabilities because you run up against some issues with estate tax issues and avoiding that and being able to make gifts that also can, believe it or not, impact benefits. So for example, you can create trusts for any individual where you give them something called a right of withdrawal over any gift that goes into the trust. And particularly what you're trying to do is use something called the annual exclusion, which is a gift. Like I can make a gift to any other human being every year of $19,000. I can also make that gift to a trust as long as I give the beneficiary under the trust the right to take the money out within a certain period of time. The problem when you do that with somebody who eventually you may be applying for benefits for is that they look back, Medicaid will look back and say, wait a minute, you had a right to withdraw this money, you didn't take it, and they will subject that individual to what's called a penalty period. So if you're going to do that kind of planning, you really need to stop doing it like at least 5 years prior to any application for SSI benefits. So one other thing that comes up is 529 plans. 529 plans, you can put money in, but they're geared towards education. And so if you are not sure whether your child is going to be able to utilize a college fund, or remember, it can also be for trade school and lots of other kinds of vocational education expenses, that's a wonderful mechanism. But if you're doing it knowing going in, depending on the level of disability of your child, that it's not going to be used for education, it's going to be a little bit expensive on the back end to get that money out because it's designed for education. If you take it out for another purpose, you're going to pay income tax at the time you take it out, as well as a penalty. there was also a discussion about, so that's fine, but then there's a certain amount that now the rules have just changed relatively recently, that you can take out and convert to a Roth IRA. And someone had asked, well, how does that work for an individual with disabilities? The problem with doing that, well, it sounds wonderful, is that now you're putting assets into the disabled individual's own name, because the Roth IRA, remember I said IRAs have to be in your own name? These do too. So now you've put assets into the name of the child with disabilities, and that will make them ineligible. The other thing is it's limited to a $35,000 lifetime amount, so it's not that much. But that is something that people do wind up doing, is they plan with 529 plans if they're not sure, and it's a way to get some money set aside. Another mechanism would be life insurance. And you can do that depending on the amount. You can simply just do that and provide that the death benefit be paid to the special needs trust under your revocable trust. Or if it gets to a point where you're concerned about estate tax, then there are what are called irrevocable life insurance trusts that you can create for that purpose. And that's a whole discussion I'm not going to get into in this, because that's pretty complex. And I'm not really going to get into tax planning, but just for your purposes for tonight, you should understand that you live in a state where the estate tax exemption is now $4 million. So that if you pass more than $4 million to a non-spouse, there will be Illinois estate tax that is due. And that includes the proceeds on life insurance. So it's not the cash value, but it's the death benefit. So you might, have very little in assets, but have a $5 million policy, and you could wind up with some estate tax. So there are questions about that at all? I know that was a lot to talk through.
The beneficiary for the life insurance, should it be the trust or should it be an individual?
You always, when you're doing planning, if you've done what we talked about in the very beginning, which is a pour over will and a revocable trust, if you're not concerned at all about the estate tax issues, you're always going to want, ideally, you're going to want to make it the trust. Sometimes for married couples, we do something called a joint trust, especially for married couples who, even when you add everything up, it's, they're well under the $4 million threshold, because you can pass all your assets to your spouse without any estate tax when the first of you dies. The issue is, if you're a couple, when you combine everything, that you're over, you've lost that $4 million or some portion of that $4 million exemption when the first spouse dies. But if that's not an issue, then you might name each other and make your revocable trust, your joint revocable trust, the final recipient.
If you're divorced
If you're
and
divorced, then you definitely want to name your trust.
okay, not the individual, right? Not the
Yes.
child.
No, you never want to name a child, because that goes back to what we talked about at the very beginning, which is guardianship, right? If you have a child under the age of 18, if you name a child, you now have to go in and, you pass away and they are going to inherit life insurance. You're going to now have to open a guardianship for them. And the guardianship court is going to oversee those funds, and then they're going to get those funds at 18, which is not what you
So
want.
I'm sorry, I misspoke. So even if the child is 18, you shouldn't name them. You should still put the trust, right?
Well, again, what I guess I would say is I don't know, I don't really know any parents who, when their child is 18, they want them to get money immediately. I mean, kids turn 18 when they're seniors in high school. I don't know, like, I mean, when my kids turned 18, I was pretty clear. Wow. I mean, they call it adulthood or majority, you've reached majority, but they're still children in so many ways. So that's why I do strongly encourage people not to do that. Of course, if you feel strongly that your child would be capable, you could do that. You could name a child followed by the trust. But in my experience, and I've done this for almost 30 years, most parents don't feel that children at the age of 18 would be ready. Now, if your child is 40, maybe, it would depend on the circumstances, but typically what we try to do and try to accomplish is having everything go through the trust. Because what if your child predeceases with children? You probably have provided for that in your trust document, but if you've only named them and you haven't named the trust, then what happens? So maybe each person's facts and circumstances might dictate that you might name an individual first, but then make the trust the secondary beneficiary. But that's typically what we recommend is starting with the revocable trust in most circumstances.
Someone asked, why would you not name your spouse as the beneficiary? Why would you put a trust? Why would you put a trust before a spouse?
Well, the reason you might would be, as I said, it would only be if you had estate tax considerations. So when we do non-tax planning for married couples, they're well below the threshold of $4 million. They're not concerned it's going to grow. Our plan then is that they name each other and they name the trust second. So that basically they kind of bypass the trust until the second of them passes away. It gets fully funded at that point. Anything else? So I wanted to go back and talk a little bit too about, because I mentioned this briefly, how you treat your children when you have when you have one child or more who has a disability and other children or child who does not. This comes up a lot when I meet with clients. There's a lot of concern about, do I give unequal amounts? And the other concern is, do I put the siblings in charge at some point? I will tell you that even though there may be disparate needs, children feel badly when I've sat in enough of these meetings if they're not treated equally. So I really do recommend wherever possible to try to think of your children and treat them equally, even though I understand that the circumstances may be different. The other thing that happens is if you have a child who is a young adult with a disability, and you are caring for them, I often have parents who want to name the siblings, especially as they get more mature, as the successor trustee or the trustee of the special needs trust we create for the child with a disability. I will tell you that the best relationships between siblings are ones where a sibling is not serving in that capacity. It's very difficult for the siblings as it is, and to ask them then to become the gatekeeper for their sibling over all expenditures creates a lot of antipathy and friction. And often, even if they're named, they wind up stepping down. So ideally, you want to try to name either an independent individual or somebody that's a little bit more removed from the situation. Sometimes people have a friend or another family member who they feel might have enough expertise. And then ultimately, probably backstopping it with a not-for-profit trustee and or a bank to step in. So we talked a little bit about, so we talked about that. So adulthood, the two things I guess I want to talk about, and I mentioned this before, and so I apologize if I'm repeating myself, but I do think it bears repeating. As your child is getting closer to adulthood, there are two things I want to encourage you to try to consider. And this goes probably this would go specifically for a child that you would anticipate needing a guardianship. If the child is able to articulate wishes and understands at some minimum level finances and can articulate their wishes about healthcare, I would strongly recommend that you get that child to sign powers of attorney instead of going the guardianship route. I think it is much better for anybody to not have to participate in the guardianship world if they don't have to. I have many cases with people who are getting all kinds of benefits, who have powers of attorney and have family members who are able to act for them. And I do think it's preferable. The other thing is, and this is a much harder thing to consider, but as soon as it is clear, if it becomes clear that your child is not going to be able to work, I strongly encourage people to apply for SSI benefits and any other kinds of benefits to which the child may be eligible. There are waiting lists for all kinds of services out there. And even kids who are in programs where they're able to stay in high school through age 22, the schools don't tell you that you can apply for benefits the minute that child turns 18. But that's really critical, because that gets you on the PUNS list, that gets you all kinds of services that will really make it easier on everybody going forward. Obviously, if you don't know, you're not going to do that. But I do encourage you to keep that in the back of your mind. And the last thing I guess I would say is just, keep in mind that, as I said, disability is on a spectrum. It's often hard to discern whether what services your child is going to need and what supports. It really takes a village. I really strongly recommend that where you can, use groups like this one for support and also for resources. Look at private case managers if needed, advocacy groups, financial advisors can be really key in determining what you're going to need financially for your child, and obviously getting an attorney to help you with putting a plan together. But I think that's really critical. My oldest child has some disabilities, and it has been a journey for my husband and I, and we both work in this field, but it has been really helpful to have those supports for us as we've gone through that. So I encourage you as well. And I'm here for any other questions you might have at this point.
Thank you.
Hi, I had another question. When I went to my son's recent IEP meeting, they mentioned this ABLE plan that Illinois has started, I think the last couple years. It's like a 529, but also expands to like medical costs. Now you don't have to wait. Have you heard of that
Are you
plan?
talking
It's
about
called
an ABLE?
ABEL.
Are you talking about an ABLE account?
I believe so. Like, cause you were talking about like saving funds.
Yeah.
So is that something you recommend and have seen? I don't know if that's beyond the scope of this talk, but since
Well,
we're talking about 529s a little bit, do you think that's been a good plan to invest in?
so
Meaning like save money through and use to pay for medical costs?
Well, I think it can be, but here's what I would say about ABLE plans. ABLE plans are, if we're talking about the same thing, are a form of an account that you put money in. The individual has to meet the definitions that we're talking about, and typically has to have been determined by age 26 for you to put money into an ABLE account. So I've always assumed that the only ABLE accounts that ever get funded would be for adults where there's already been an SSI determination. The other thing to keep in mind is you can only have $100,000 in an ABLE account and still qualify for SSI. And finally, because it's an ABLE account, and I didn't really get into this about the first party and third party. Remember, I said they're different. One of the ways they're different is first party account. So an ABLE account is kind of an option instead of doing a first party trust. But both of them have what's called a payback requirement. So if the money in them does not get used during the lifetime of the disabled individual, the state of Illinois actually has a priority lien against those funds. So it's essentially almost like it's a deferral, right? It's basically you're paying and having this money put in there, but if something were to happen to the disabled beneficiary under either of the trusts or under the ABLE account, those funds have to go back to pay whatever benefits that individual received during their lifetime. So it's not the same as a third party trust where you set it up, it's available for the lifetime of the beneficiary. And then if there's still money when the beneficiary passes away, it can pass under the terms of the trust document to other individuals without any payback requirement.
Okay. I don't know if this seems different than what I was given as the pamphlet. It almost seemed like accounts, like a 529 account that you could use now to pay for medical expenses, and whatever was remaining, you could apply like as a 529 for their education. You can roll over a traditional 529 into this ABLE plan. So it seemed like a different plan than what you're talking about.
Yeah, and then I'm not sure what you're referencing. I will
Okay.
say that, and this is why I mentioned all of these different professionals. As
Yeah.
as the estate planner, I know some things, but I rely heavily on case managers myself, for helping clients figure out the best benefits, or financial advisors. They often find out about some of these programs before I do. So if it's different, I mean, I'd love to hear about it. So if you share it with Kate, and I could look it over, and I'm happy to talk with anyone offline too. If, Kate should feel free to give my information. If you want to send it to me, I can look at it and see if it's different than what I just mentioned. But ABLE accounts are a specific kind of account out there.
Okay.
And that's what I thought you were
And those
referencing.
have been around for years, the ABLE accounts that you're talking about?
Been around for, I don't know, 10 years maybe. I mean, they haven't been around
Okay.
forever, because when I
Okay.
first started practicing this area, the only options were third party and first party. And then in more recent history, ABLE accounts came into being. And they were kind of tied to the 529 thing, but so it allowed you to make annual exclusion gifts, to use that and put it into the ABLE account. For the individual with disabilities. The problem was, I mean, it's not a problem, I guess, but it has a limit on it has that $100,000 limit, which isn't that helpful if you're getting SSI, and it did have to pay the clawback at the end.
Okay. Yeah, I'll send the flyer that I have, because it did seem different than that county that you're talking about.
Yeah, absolutely. Absolutely.
Someone said in the chat, she thinks it is the same plan, but school districts are not well versed. As a teacher, we're given a paper to hand to parents and are unsure of parameters or ins and outs.
Okay. That sounds like that might be the case. And I'm not saying they're bad. It's just there are always a lot more the devil's in the details, as they say, right? There's always a lot more to it when you look at it. And again, ABLE counts are really wonderful if somebody inherits a smaller amount. I mean, we used to have to set up these trusts for people getting, $10,000, or, I mean, that's what it can alleviate, is the need to have a trust document created, a trustee on board. I mean, so it really does fill a very specific need, but it is not a great mechanism for savings. It's not optimal, I guess I would say. In many ways, a 529 might be better, even though you pay some tax at the back end, right? It is going to never have to be paid back to the state. And you can always change the beneficiary on a 529 plan. So if the disabled individual doesn't use it, it could then be used for someone else for education, where there wouldn't be any income tax paid or penalties.
Interesting. So on a 529, if you have one kid as the beneficiary and you realize they're not going to use it, you can switch it to the other kid's name.
Yeah. And you can also take partial withdrawals from one to another. So like you can keep them in both their names, but you could, you could decide, okay, you know, Johnny's at Harvard, and Stan is at Roosevelt. So I'm going to take some of Stan's money and put it into Johnny's account. You can do that once a year, every 12 months. So yeah, that's pretty flexible.
What about if one kid is you're gonna roll it over, you have plans to roll it over into a Roth IRA. I think you said there was some disadvantages of doing that. Can you repeat what those disadvantages were?
Well, the Roth IRA is new, and this is what I understand, is that you can roll out, if you ultimately determine that the money is not going to be used for education, you can roll out a certain portion to a beneficiary. The lifetime maximum for each beneficiary, though, is only $35,000. Okay, but I'm not saying that's nothing. Plus, you're limited by the timing on rolling it out. The account has to have been in existence for 15 years. In
Mhm.
addition, you can only roll out the amount that you could set up a Roth IRA each year, which I believe is $7,500 per person.
Mhm.
So if you're going to do $35,000, you're going to have to take a couple of years to do that. The
Mhm.
last thing is when you do roll it out, it has to go into the name of the beneficiary.
Oh,
So,
yeah, that's right.
so that's the issue for a child who's receiving benefits, means tested benefits. Now, some kids, remember, are depending on when their disability is determined, will qualify under Medicare and Social Security disability once their parents retire. And then it may not matter as much. And then you could roll it out because you can get Social Security disability and have $100 million. They don't look at your income when you're in that circumstance. But that many people don't qualify under Social Security, their parents' Social Security disability, or certainly not at the time. And it just depends how long you want to keep that account in play.
Could I
Have
just,
you,
oh, sorry.
that's okay. Have you worked with, or do you work with, federal employees because their benefits are a bit different than most companies?
I have worked with I have worked occasionally with a federal employee or two, and I've also worked with a number of teachers and other and who have different retirement options and pension options, and we have worked with them to name a special needs trust as the beneficiary because oftentimes their children normally pensions end after the spouse, but if you have a child with a disability, their pension can continue. And so we've done that a number of times. You have to really, they really have to do the legwork, the client, and talk to their HR departments to figure that out. But once they do that, you can then make sure that those funds go into the special needs trust. We can put in a savings clause that to the extent anything that goes into a special needs trust would be considered first party funds, that portion would be subject to payback and nothing else. But honestly, I have yet to see that problem arise. And we have had a number of individuals' pension funds go into special needs trusts for their dependent and disabled child. There's also some, they have to meet other obligations, like they have to maybe treat their child as a dependent on their taxes for many years. We've been able to go back and clean up tax returns for that reason.
So if we're divorced and we're splitting the kids, right? So the child with a disability should go on the federal employees claim every year,
You mean, yeah, I mean,
right?
ideally, yes.
Yeah,
If
because we're
that federal
switching
employee, yeah, if that federal employee is going to have benefits at the end that that child would qualify for, yes, I
the
would say,
pension. It would be the
yeah,
pension because we're
yeah,
divorced, so it would go
yeah,
straight to her.
yeah. Then I would
Okay.
absolutely, yeah. If
So
you're
he needs
talking
to be
about which,
claiming her.
yeah, I would
Okay.
claim, yeah,
Thank you. That's good information to know because it's not set up that way right now.
okay.
Is that the same for the teacher retirement for TRS?
Yeah,
That the pension would go
yeah, I've
to?
worked a couple times with folks with TRS, yes, and
And
that's
then,
a very, very helpful benefit. I mean, it's for the lifetime of the dependent adult child, which, that's huge.
and then would it, could that be like if it is your stepdaughter or stepson? Or it
That
has
I
to be
don't
biological?
that I don't know. I don't know. I'm sure it would cover adopteds, but I mean, I would guess, but that would really be a question you'd have to go back to TRS. I will tell you, I mean, I dealt with this at one time during the pandemic, and they were incredibly helpful at TRS to try to help work it out. And, we had to go, like I said, in this particular case I'm thinking of, it's happened more than once, but this one, I remember we had to go back and have them amend tax returns for a couple of years, even though the child we were talking about was a 50-year-old who had schizophrenia and had been living at home with mom her entire life. So, I mean, yes, I think they really do try to bend over backwards to help family members.
Thank you.
Anything else?
Is there a good place for people, whether it be, right, like family businesses or personal donations, meant to help with cost of living expenses throughout their lifetime for at a later date, right, in adulthood, for families to be saving money for the child with a disability, presumably that they can't earn their own income, right?
So,
Other than the 529 plan and the ABLE, because we've kind of learned the advantages and disadvantages of that. Do you know of a good place other than just saving money?
well, when you say a good place, you mean, are there other mechanisms other than the ones I mentioned?
Right. Yeah. Is there other options that we're, really
So,
not aware of?
so the other options are get a little bit more complicated. Like, like I said, you can create a standalone special needs trust. You can try to get creative with making gifts to that trust. I have done this for some clients who we've put someone in as kind of like an interim beneficiary that has some like contingent interest and made gifts to the trust every year to that individual, and that you do that every year, the 19,000. And that 19,000, by the way, is a number that is set by the Internal Revenue Service for annual exclusion gifting.
Mhm.
And then so it could go up to 20,000 depending on the cost of
Yeah, it's
living.
just the maximum,
Yeah.
right?
Right.
Mhm.
And so you could do something like that if you wanted to. That's a pretty sophisticated planning device, but it would allow you to grow it in a trust. It could, depending on how it's structured, to you might even be able to structure it so that you're paying the tax on any income earned by the trust on your personal tax return. That would be, like a way to do it. But I don't know that there's like I said, that's also life insurance trusts can be, because that's a very leveraged kind of a investment, right? I mean, you're buying a life insurance policy and you're paying a small amount, but it also depends on how long you live, how expensive the premiums are, what's going to be the death benefit. And all of that has a lot to do with your own health and your age. And it becomes really cost prohibitive as you get older to try to fund that with life insurance. But you could, like, for example, start the trust we were talking about, put money in, depending on the size of the policy, use some of it to pay for a policy that then could be a much larger amount at death.
Mhm. You know how we're talking about TRS and like the child getting the pension?
Mhm.
If they're getting that pension, like would that be through the trust or they just be directly receiving that pension?
So what we were able to do was get the pension to go directly into the trust. So it wasn't going to the child, it was going to the child's special needs trust. So it was bypassing the child to allow them to be potentially eligible for benefits. And I mean, there were a lot of complications in this particular factual
Hmm.
situation. This child had been working at times and not, and so they had their own money that we had to work through spend downs. But yes, it was going directly into the trust and not into the hands of the child. So it would depend. It would depend on the way you structure it. If it goes to the child, they will not be eligible, usually with a pension of that size, for means tested benefits like SSI. That's also what happens when you have children who receive SSDI. They no longer qualify typically for the SSI because the SSDI is so large.
Yeah, that's what I was wondering. So if they're getting the pension or the TRS, like they're not then getting the
Well,
disability.
that's why we
Mhm.
had it go into the trust as
So then
opposed
they
to
could get it,
that.
right?
Yes, yes. And
Okay.
that's why when we were doing it that way and working with them to make sure that it was funded that way.
Okay.
But that
Thank
was
you.
done by just so you understand, that was done by the participant while the participant was alive and naming the special needs trust. It's almost impossible to do after the fact.
Right. So they have to be setting it up now and working with their HR department as well as a lawyer at the
Yes.
same time
And
simultaneously, correct?
that's a circumstance, like that kind of situation is one where you would want a standalone special needs trust because you want to have something that exists that it's going to.
Okay,
Yeah,
thank you.
absolutely. Absolutely.
Folks, it's 8:10. I just want to say if anyone needs to roll off or has a final question, I'm happy to stay on a little longer. I think Margot might be as well. But thank you all for coming. We've had a couple of people already who I'm sure have had to step off for other commitments, but any closing questions before we sort of wrap up?
I have a question about any of like the savings or any of the different things. Like, is there something when you put the money in? I think you were saying it that you pay the taxes now, and then that way when it's in the trust or whatever, like they get it out like tax free,
It wasn't
and they're
that
not
you
paying.
pay the taxes now. It has to do with how trusts work. It's kind of a little bit complicated. There's a thing called the grantor trust rules. And depending on who creates it and who is managing it, you can potentially have a trust where I set it up. I name my spouse, for example, as the trustee, and I put money into it for a child of mine. Because my spouse and I are the creator and the trustee, it's treated for income tax purposes as if it's our money. So any growth on that money, any interest that's earned, comes back to us to pick up on our personal income tax return. So it's like a backhanded gift, which can be a pro and a con, right? Because now you've got more, you're getting taxed on money, but only on the growth, remember, only on the interest that is earned by that money. But it is a great way to get money out to the child. Now, eventually, when we're both gone, it will no longer be a grantor trust. But if it's structured as a special needs trust, it will get taxed, and especially as something called a qualified special needs trust, it will get taxed at a different rate, at a lower rate than trusts normally get taxed. And so that's what I was referencing.
Thank you.
Sure.
Could I ask a final question? Say, it seems like there's a lot more trust than I never even knew existed that you have spoken about. Are there just like so many different options? And I know you focused a lot on the special needs trust and things. It just seems like there's so many different options, right? And that's why seeing a specialist like yourself that would know all these ins and outs, because it seems, is that a true statement that there's a lot of different avenues for the special needs trust that you can kind of pick and choose based on your specific individual needs and for
Yeah,
your
well, I think
child?
that's true of planning in general. I mean, I think it also has to do with, how much money you have available to set aside. I mean, the reality is for many of us, raising children is expensive. I remember when my kids were in high school, one of the teachers sent around a picture at one of the parent nights of a yacht and said, if you didn't have a child, you would have this, and then send another picture of a yacht that was twice the size, and if you didn't have two, you'd have this. So the what I'm talking about can get very expensive, and the reality is it may be hard enough just to make sure that you're getting the supports you need to get the services in place to try to get your child as much independence as possible. But yes, there are all kinds of trusts out there that you can utilize both for special needs purposes and also just for tax purposes, state tax purposes as well. But it may be more complicated than you need, right? At the end of the day, maybe what you really need is just to make sure that you're fully funding your own retirement, and then if there's a little bit of extra, maybe you buy an insurance policy that you hold in your own name, because it's only a concern, right, for an individual who has more than $4 million. If you have less, you don't have to do all of this. You can just buy, have that life insurance policy, for example, and have it just go into your own revocable trust, the one we talked about at the very beginning, just your testamentary plan if something happens to you. So I don't want to give you the impression that you have to do all kinds of fancy planning, but that can be part of it as well. Because the other reality is, even people who are wealthy, if they have a disabled child, their child will not be eligible for a lot of the benefits that are out there, including housing and programming, unless they're made eligible, which is kind of crazy when you think about it. But that is the truth. And that's why some of that more sophisticated planning happens.
Will we know how to get a hold of you? And like, will you know that we came from here?
If you let me know, sure. I've mentioned this to Kate that I will send around. I probably won't be. I won't do it today, but before the end of the week, I will send her the list of case managers and benefit specialists that we've utilized in our firm. It doesn't mean that you'll love all of them, but they're a fee for service place, but they're social workers by training who have experience both with benefits applications and also with finding resources for families and for individuals with disabilities. So that can be something that you can reach. You can reach out to any one of them at any future point if that would be helpful. But in many ways, some of the most helpful things are just informal groups like this and creating support groups. I mean, when we were raising our son with some of his disabilities, just having other parents who were friends and talking through what are you doing and how is this working and how's that working was really helpful because it's difficult. It's difficult enough to raise children, but when you're worried about their ability to get to independence, it adds more stress. So I strongly encourage you to get the support you need as you go through this.
Thank you. I think that's a lovely place to end. I want to release everybody so we can go about our evening. In the next couple of days, I'll edit this recording and send that out to you. If you're here because you got an email from us, you will get that as well. And maybe I'll wait a few days to see if I can get that list from Margot of the case managers and benefit specialists, because that might be an important part of planning for some folks. All right. Just want to say thanks again to everyone for joining us. We are so grateful for your time on this Tuesday night. Please don't hesitate to reach out if you have additional questions. Remember that we also have our education coordinator, Dr. Anna Tess on staff, who can help with all those IEP and 504 determinations if you're working through those at this time, and can also offer helpful resources, maybe more specific to the DHH community. Margot, thank you so much for joining us, for sharing your expertise, some of your personal story, and some really great advice with this group. I know it was deeply appreciated by so many, and we're so grateful to have you in our wider network of support for our DHH kids. So thank you.
Thanks again for having me, and thanks for all the wonderful questions. I did not fall asleep, so that was wonderful.
Glad we kept you awake. All right, everyone. Thank you again so much for joining us, and have a great night.
Thank you for watching. To learn more about the Foundation for Hearing and Speech Resources and our child-centered, research-backed programming for children and families living with pediatric hearing loss, visit FHSR.org or find us on social media at FHSR.Chicago.